Hello and welcome to Topic 5, Lecture 1. And in this, we're going to be talking about civil rights, equality, and the U.S. Constitution. So what are we going to be covering in this lecture? Well, first we're going to revisit some key terms, just so we're all on the same page. Then we're going to talk about the role that the Constitution plays and the meaning of equal protection of the law. Then we're going to look at the difference between justified and unjustified, unequal, or different treatment. And then we'll talk about the levels of scrutiny that are used by the Supreme Court in civil rights cases. So this lecture is designed to give you sort of an overview of the role that the Constitution plays and the Supreme Court plays in civil rights cases. In our next lecture, we're going to take a look at the civil rights movement, like historically in the United States. So let's get started. Okay, so we just got done with topic 4, chapter 4, with learning about civil liberties. And so as you all are well aware, that civil liberties are the individual rights and personal freedoms with which government are constrained from interfering. Okay, so last week we learned about the freedom of speech, the right to bear arms, the rights of the criminally accused, etc., all examples of civil liberties. And this week, we're going to dig into learning about civil rights in Chapter 5. So as you know, we talked about this in last week as introducing this concept, but just wanted to make sure we introduced it again. So civil rights are the obligations that are imposed on government to guarantee equal treatment and to protect citizens from discrimination. And that's oftentimes referred to as the equal protection of the law. So let's take a look at where we find the equality or the equal protection of the law in the Constitution, and then let's define equal protection of the law. So following the Civil War, 3 amendments were added to the United States Constitution, and that's why they are sometimes referred to as the Civil War Amendments. And let's take a look at all 3 of these, and then we'll spend special time on the 14th Amendment because it's in the 14th Amendment where we find the Equal Protection Clause. So the 13th Amendment was added to the Constitution in 1865, right towards the end of the Civil War. And the 13th Amendment abolishes slavery in the United States. You might think, why did we need that? Because of the Emancipation Proclamation. But you should keep in mind that the Emancipation Proclamation only applied to the Confederate States. It abolished slavery in the Confederate States. And so the thinking is that after the war was over, there was really no formal abolition of slavery throughout the whole of the United States. And so that's why it was important for the 13th Amendment to be added. If you haven't seen the movie Lincoln by Steven Spielberg, starring Daniel Day-Lewis as Abraham Lincoln, I highly recommend it. That movie is about the passage of the 13th Amendment in Congress. And it's just a wonderful movie that really encapsulates the power of the presidency and the importance of passing the 13th Amendment and how difficult it was for that to pass Congress. The 15th Amendment, added in 1870, is the amendment that forbids denying the right to vote based on race or condition of previous servitude or the color of your skin. And so the 15th Amendment is the Voting Rights Act for African American men. Women didn't get the right to vote until the passage of the 19th Amendment, so that includes both black and white women. And for all practical purposes, as you will read in your textbook, that the denying the right to vote based on race really didn't end until the passage of the Voting Rights Act in 1965, okay? But the 15th Amendment was the first step towards ending denying the right to vote on race. And then the 14th Amendment was added in 1868. The 14th Amendment has a lot of provisions in it, so let's go ahead and take a look at the provisions that are sort of most important in terms of equal treatment. So there are many very important aspects of the 14th Amendment that have to do with equality in the United States. So let's take a look at some of the provisions that are in the 14th Amendment. The first and very important thing that the 14th Amendment does is that it establishes what's known as birthright citizenship. If you're born in the United States, you are a citizen. And the reason that that is included in the 14th Amendment, it could have very well been that following the Civil War, that state legislatures could have defined, or the national government could have defined citizenship as having to do with something more than being born here, right? You could say, well, just because you're born here doesn't make you a citizen, but you'd have to have a further stake in this country, right? Like that only people who are only people who are born of citizens of the United States would be considered citizens. You could also say any former slave is not a citizen, or any person who was born of a former slave is not a citizen. And so the 14th Amendment takes all that off the table. Basically says, if you're born here, you're a citizen. End of conversation. And so that makes sure that all former slaves and all people who are born of former slaves, they're all citizens of the United States with the same rights and duties and obligations as all other citizens. The other three provisions of the 14th Amendment that we're going to talk about, I'll just put them all up here at the same time. Then we'll talk about them each individually, and I won't go into too much details. The Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause are all telling states that they can't do certain things, okay? So, these, as we learned last class period in our civil liberties, there is a sense about whether or not the Bill of Rights applied to the states, or did it just apply to the federal government? And so as we know, that after the passage of the 14th Amendment, it became clear that the Bill of Rights did apply to the states because, as you see with the Due Process Clause, that no state can deprive a person of their life, liberty, or property without due process of law, okay? And so, coming out of the Civil War, we were really worried about states, particularly the former Confederate states, that they were going to enact laws that were taking away rights of the citizens of the United States. You see the first one is called the Privileges and Immunities Clause. There was a concern that states would take away certain privileges or benefits of being a citizen of the United States, particularly citizens who were former slaves, okay? And so that says no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. And so this was thought to be that states can't take away the right for blacks, former slaves, to find employment or to travel on roads or, own property, right? And so that was put in. Privileges and Immunities Clause has not really been used for matters of preventing discrimination. It hasn't been used for civil liberties either, but still important to know about it. Due Process Clause, we talked about that last in topic 4, that states can't take away your liberty, your life, or your property without a fair process and a known process. But what's most important to us here is the Equal Protection Clause. It says that no state shall deny any person within its jurisdiction the equal protection of the law. And that's where we really find the fight for and civil liberties, the obligation that we place on government to make sure that people are treated equally. So let's talk about what we mean by the equal protection of the law. So what is equal protection of the law? Well, according to Cornell Law and their Legal Information Institute, equal protection forces the government to govern impartially, to not draw distinctions between individuals solely on differences that are irrelevant to a legitimate government objective. In other words, more basically, it's just treating an individual in the same manners as other individuals that are in similar circumstances, okay? And so here's an example of where equal protection of the law might be violated. And so you have two people, they're convicted of the same crime, that the manner in which they committed the crime, their background, very similar circumstances, okay? And so you would expect them to get the same sentence. But and that would be equal protection of the law. However, if you have two people convicted of the same crime under very similar circumstances, and let's say the one person is a man and the other person is a woman, and the man gets the death penalty and the woman gets, 30 years in jail, you'd say that doesn't seem to be equal protection of the law, because how is that seems irrelevant to a legitimate government objective of keeping people safe. You could say the same thing, a black person and a white person gets the lesser sentence, black person gets a more serious sentence, even though convicted of the same crime, same circumstances, etc. So that might be an example of when the equal protection of law is violated. Another way of thinking about equal protection of the law is the idea that you would prevent discrimination, okay? And so discrimination is different treatment. I mean, really, when you talk about discrimination, usually we think about it as a pejorative, like discrimination is like unjust or unfair. But really, discrimination is really just treating people differently. The thing is that some types of discrimination, different treatment, is making distinctions between individuals that are irrelevant, not based on reason. Sort of what the example we used on the last slide, where we were saying treating criminals convicted, same scenario, same circumstances around the crime. The only difference is the race or their gender, right? That would be seen as it is different treatment, but it would be considered impermissible different treatment, and therefore unconstitutional or illegal. But some types of discrimination or different treatment can be permissible if there's a legitimate reason for the different treatment. Okay, so let's look at some categories of ways in which people are treated or groups of people are treated differently, and ask yourself, do you think that this different treatment is justified? Should it be permissible by law? Or do you think that this kind of different treatment is more based on a distinction that's unimportant or irrelevant to the larger goal that the government is trying to achieve? So what do you think? Is it permissible to treat these groups differently? Let's take a look at the groups, then I want you to pause the video, and I want you to take a moment and sort of ask yourself, with these groups, where do you feel that different treatment, that there are really no or very little grounds that are justified to treat these groups of people differently? So we have adults and minors, okay? Is it justified to treat adults and minors differently? What about those who have a license to do a profession and non-licensed to do a profession? Men and women, is it justified to treat men and women differently? If so, why and when? Black and white folks, is it justified to treat them differently? LGBTQ plus QIA plus folks and straight folks, the poor, non-poor, people who have a certain income level, those who don't. I mean, in what cases do you think it's permissible to treat these people and these groups of people differently? And when do you not think it's permissible or justified? So just take the pause, and then let's come back together in a moment. Okay, so welcome back. So what do you think about these different categories in terms of the permissibility of treating these groups differently? Well, let me put up, and we won't spend a lot of time here, but in the red, right, treating people differently based on whether they have a license to do a job. I think that most people would say that's completely reasonable. In fact, it might be related to a compelling state interest, right? That if you need to fly a plane, you need to be licensed to do it. If you're going to practice law or be a doctor, you need to be licensed to do it. So I don't think that there would be a lot of argument around why treating licensed and unlicensed people, you think that would be permissible, that there's not a lot of reasons for why it would be impermissible. Adults and minors, you sort of think, well, sometimes, and also the poor and the non-poor, that sometimes that there might be times when it makes a lot of sense to treat adults and minors differently, right? Minors are not, they're still developing cognitively. They may not understand the consequences of their actions. They may have impulse control issues. And so it makes complete sense to sort of say, maybe it's not maybe you should wait until you're 16 to get your driver's license, or wait till you're 18 or 21 to own a gun for minors. We also wouldn't hold minors to the same level of criminal culpability, right? You're not, 2-year-old shoots somebody, you're not going to be like, well, they knew what they were doing. No, they don't know what they're doing. They don't have any capacity to understand the difference between right and wrong. But there are other times where treating adults and minors differently probably wouldn't make sense. In the last chapter, we talked about civil liberties and the right to free speech, right? Well, I mean, saying that minors don't have any speech rights, that's not fair, right? There might be times in school where you'd say you have to curtail your speech, right? But to say that, to have a completely different treatment in terms of civil liberties between adults and minors wouldn't make sense. Same with poor and non-poor, right? I mean, it's sort of like there are times when poor and, you shouldn't look at somebody's wealth and deciding whether they can apply for a job. doesn't have anything to do with it. It would have the qualifications. Can you do the job? But when it comes to government assistance, right, that whether it's for food stamps or housing assistance or what have you, it probably makes a lot of sense to say that you have to be of a certain income level to be eligible for that assistance. Men and women, black and white, LGBT folks, straight folks, that usually can't really think of a lot of ways in which these folks are different. We do have biological differences between men and women, but to what degree do those biological differences impact our ability to be a human? Maybe there are some significant ways, and so in maybe some very minor ways that different treatment might be justified. Black and white's race doesn't have anything to do with being human, right? I mean, that your race, your skin color, your ethnicity, it's a characteristic you don't choose, and it has absolutely nothing to do with one's ability to, be a human. However, black and white folks have experienced discrimination in the United States in very different ways. And so there are some ways that being black and white is different. And so maybe the government might take that presence of past discrimination into consideration. So how do we determine which types of different treatment are permissible and which are not? Well, how we do that is through the Supreme Court of the United States, okay? So as you see in the textbook, when you have the government that passes laws that treat people differently, that question will come to the court. And the court will say, is that different treatment constitutional? Is it a violation of the Equal Protection Clause? And if it is, then you cannot engage in that different treatment. But the Supreme Court is the one that decides, and what is permissible changes over time, right? From Plessy versus Ferguson at the end of the 19th century that says separate but equal, right, to Brown versus Board of Education in 1954 saying separate treatment is absolutely unequal and therefore unconstitutional. So we depend on the Supreme Court to determine what is permissible or impermissible discrimination. And the court uses different tests and different standards or what are known as tests to determine whether the different treatment is permissible and thus constitutional. And so we're going to take a look at the three tests. The higher the test or the higher the level, your textbook talks about it as levels, the harder it is to justify, for the government to justify this different treatment, okay? So let's take a look at the tests so that we get a better understanding of how the court makes a determination about whether or not different treatment is unconstitutional. Okay, so let's talk about the first or the lowest level of test that the Supreme Court used when it comes to different treatment, and it's known as the rational basis test. This, as I stated, is the lowest level of scrutiny that's used by the courts. And the burden, so if there is a law in place that treats people differently and the rational basis test is used, the burden is on the individual who feels like they're being discriminated against to prove that there's no reason for this different treatment. In other words, there's no rational basis for this law, okay? And so basically that's why it's called the rational basis test, that if the government can say that there's a reason for this, the individuals being discriminated against has to say there is absolutely no reason for this. And that's pretty difficult to demonstrate or to show if the courts are using the rational basis test. And that's why it's sometimes referred to as the anything goes test, right? That when the court uses the rational basis test for scrutinizing different treatment in the law, it's pretty hard. All the state has to demonstrate is that there's some reason for this different treatment. So when this test is used, it's very difficult to show that the law is unjustified. Anything goes. Today, it's mostly used for regulations. So kind of some of the things we were talking about on the last slides. And so like licensures for cars and jobs. All the state has to show the rational basis test is used, and all the state needs to show is that there's a rational reason for making people have have licenses. When you differentiate between age, saying there's a minimum age to drive a car or to purchase tobacco or to buy a firearm, right? The rational basis test will be used. Same when it comes to income and income qualifications. It used to be used for gender. So when men and women were treated differently, anything goes. Like all you had to say is that there was some reason for that different treatment, that it wasn't completely irrational. And then that different treatment was justified. But the rational basis test is not used for gender anymore. It uses the next test, which is known as the intermediate scrutiny test. So let's take a look at that. Okay, so let's talk about the second level, the intermediate scrutiny test. In this level, the more burden is placed on the government when this test is used, okay? And so for a law that differentiates, treats people differently, the government must show that the law is reasonable. However, not only is the law reasonable, but it also serves an important government interest, okay? So just saying that it's reasonable to treat people differently isn't enough. That reasonable treatment needs to be related to something that's really important, that a goal that the government is trying to achieve. This is the test that's used on laws that differentiate on the basis of gender and sexual orientation, okay? So if there's a law that treats men and women differently or treats gays, lesbians, and straight folks differently, the court, just showing that there's some sort of rational basis for that difference, it isn't enough. It needs to be related to an important governmental interest. It's a lot more to discriminate when it comes to when this test is used, but it's not impossible. And here's an example. And so today, that there are not a lot of laws in the books that treat men and women differently, right? So that you can't discriminate between men and women on job applications or applying to schools or, a whole host of, we don't have protective labor laws that say that women can only work, so many hours because that's reasonable because women have to take care of kids, that's not, we don't have laws like that anymore. However, we do, only men have to register for the Selective Service. Women don't have to register for the Selective Service. And this question actually came to the Supreme Court in the 1980s, and they said that using the intermediate scrutiny test, they basically said that, yes, this is rational. Not only is it rational to treat men and women different, but treating them different achieves an important government interest, and that important government interest is national security, okay? And that at that time, women could not serve in combat roles. And so the thinking was, if women have to sign up for the draft, but they can't serve in combat roles, that's going to jeopardize our national security. And this question has come up to the Supreme Court again for asking the Supreme Court to review the Selective Service law, saying that only men have to apply, because today, women can serve in combat. So what is the important interest here, preventing women from signing up for selective services? The Supreme Court has refused to hear the case, so we really don't know the answer to the question. However, maybe Congress could pass a law mandating that both men and women have to sign up for selective service, and then maybe that law might be challenged and we get the answer, okay? But it's just an example of the important interest having to do with national security. Now, this brings us to the third level, the strict scrutiny test, okay? And when there are some types of different treatment, when law treats different people differently, there are some types of different treatment that kind of raise a red flag for the Supreme Court. And that they basically assume that this different treatment is unjustified and unconstitutional. And they're going to give that different treatment strict scrutiny. And that's why they used a strict scrutiny test. And so if you have a law that treats black and white people differently, different ethnic groups differently, people of different religious groups differently, or their country of origin, their national origin, there are laws that treat these groups differently, it basically, the court assumes that these laws are unconstitutional until the government proves otherwise. That's because classifying people on race, ethnicity, religion, or national origin are considered to be suspect classifications. Why? What do we mean by that? Well, what we mean by that is that when the different treatment is based on what's known as an immutable characteristic, a characteristic that you can't change, and also where that characteristic has no reasonable relationship to being human, then when you are differentiating between those groups, it's sort of like, why? On what basis? Your skin color, your race, doesn't have anything to do with your capacity as a human, what your religion is, what your national origin is, what country you're born. Those are characteristics you oftentimes don't have any control over, and there doesn't seem to be related to anything, in terms of what it means to be human. And so when those differences are made, the strict scrutiny standard is applied. Also, that another red flag that's raised is that these groups have been treated differently historically. And so these suspect classifications, these classes have a long history of discriminatory treatment in the United States. So when laws are trying to treat these groups differently today, then you basically say, wait a second, is this playing into this long historical different treatment that used to be allowed but is no longer allowed? Okay. So as I mentioned, that laws that treat these suspect categories or classes differently receive strict scrutiny from the court. And the burden of proof is on the state. The state must show that the different treatment is related to a compelling state interest. So not just an important state interest, but an interest that is so crucial or is essential to the job that the government is doing. Not only that, but they have to say that this different treatment is related to achieving a compelling state interest, and the only way we can achieve this state interest is to do it through the way that this law has been designed. So it's the compelling state interest that is achieved in the least restrictive way. That is the test that the court uses. Now, most laws that differentiate on the basis of race, national origin, religion, ethnicity are unconstitutional. In other words, the strict scrutiny test is oftentimes known as strict in theory, but fatal in fact. So that when laws that differentiate on these things come to the court, they're almost always found to be unconstitutional, but not always. And affirmative action is a really good example of different treatment based on race that is constitutional because it's related to a compelling state interest and it's achieved in a very least restrictive way. Okay. So affirmative action is policies or programs that are designed to remedy past injustices. Okay. And so as we were talking earlier, that one major difference between maybe men and women and major differences definitely between black and white folks is that white folks have not experienced the same sort of historic discrimination as black folks have, right? As being most African Americans are descended from slaves, and that until the 1960s and even beyond, right, there have been Jim Crow laws, basically legalized discrimination in the United States. And so that, coming out of the Jim Crow law era, right, that there was a move to basically say, look, that you can't just end discriminatory laws and then just assume that everybody's going to be treated equally. That there's this residue within our nation that is still present, this residue of racial discrimination. And so affirmative action is an effort designed to remedy these past injustices. And so affirmative action could be giving racial groups extra points applying for federal jobs, or that it could be that you are making sure that when you're announcing a job that you make sure that you target underrepresented neighborhoods or underrepresented areas, right, as a way of trying to create a more diverse workforce. And we see affirmative action in schools, right? That in the United States, when you apply to college, colleges can take race into consideration among the other things that they consider. And the compelling state interest there is diversity, making sure that the college classroom is diverse, because viewpoint diversity and racial diversity and ethnic diversity are important components of higher education, right? Because you get a marketplace of ideas and oftentimes values and beliefs, not always, but can be related to one's lived experiences, okay? And so with affirmative action, the idea is that you're repairing, the compelling interest is that you're repairing past harms and injustices, and that's why these kind of different treatments are allowed. But But we will see that, and you'll talk about this in the textbook, that, it's becoming more and more difficult. The court is finding, as we move away from the Jim Crow era, the 1950s and 60s, it's becoming more and more difficult to justify the need for affirmative action laws. Okay, so we've got the constitutional and sort of legal background on thinking about equality. The next slide, the next lecture you're going to be watching is about the actual fight for equality, fight for demanding government to treat people equally. And so the answer to is different treatment based on race, sex, religion, ability, permissible. It's a very important question because when we get the answer to those questions from the court, it defines civil rights policy and law. And so when the courts used to say that something was justified and legal and constitutional, that had an implication for public policy and law. When the court says, nope, that different treatment is absolutely unconstitutional, it has implication on policies and laws. And so as the change to the answer to that question, is this different treatment permissible? Policy changes and law changes. And so just think about from Plessy versus Ferguson, where they said separate train cars, separate accommodations, as long as they're equal, that they're separate but equal, constitutional. Well, when the Supreme Court, a mere 60 years later, revisits that case about separate schools, right, segregated schools, and they come back and say that they strike down the separate but equal rule, right, saying separate is not equal. Separate is in fact unconstitutional. Now, keep in mind that change doesn't just happen. It is a product of hard work. It's the product of people demanding change in the laws, struggling, raising consciousness about unfair and unequal treatment, right? And so the next lecture that we're going to take a look at is going to look at that history of the civil rights movement and how the civil rights movement has expanded beyond race to deal with other classifications of people as well. All right, thanks for listening. Really appreciate it. Talk to you again soon.